I'll tell you very briefly about Manoj. So Manoj sir was enrolled as an advocate in 1978 and has experience of practicing for more than 43 years. Sir was designated as a senior advocate by the Honorable Odisha High Court Full Court in 2011. Sir has practiced in Odisha High Court, various other high courts, in the Honorable Supreme Court of India, and various other tribunals. Sir has been a member of the Odisha State Bar Council for more than 20 years. Sir has been a member of the Disciplinary Committee of the Bar Council of India from 1997 to 2002. Sir has received various awards. I'm just mentioning one over here right now, which is the Professional Excellence Award by the Governor of Odisha, and various other awards. So all of these we'll try to share elaborately on the website, wherein you can get even better profile of Sir. But for now, considering the paucity of time and that I've already taken about 3 minutes of his time, sir, I very humbly welcome you today, and I hand over the class to you, sir.
Thank you, Mr. Sharma, for giving me this opportunity. This is really a good opportunity to at least interact with our lot of listeners. First of all, disciplinary proceeding is such a thing which is a double-edged weapon. Double-edged weapon for employees and also for management. For employees, what happens is the management wants to punish somebody or wants that the concerned employee is a undisciplined employee, is not doing his work properly or sincerely, honestly, and has been misconducting himself, then he can initiate disciplinary proceeding. So far as disciplinary proceeding is concerned, the rules are specific. First, so far the government employees are concerned, the power starts from 311 of the Constitution of India. Article 311 of the Constitution of India gives the detailed guidelines, how the basic framework, how the disciplinary proceedings have to be initiated and all that have to be conducted. Thereafter, relevant rules. So different, central government has got its, it is called central government CC rules, civil, that is called civil classification and appeal rules, and for different state governments have also got different rules, and different organizations like PSUs, like banks and other PSUs, they have also got separate rules. Some organizations, they follow the CC rules or the relevant state rules. Maybe it is a CC, sorry, proceeding, if it is a PSU under a particular state, or if it is a PSU under a particular under the central government, then they sometimes they follow the CC rules, sometimes they have also got their original rules. But basically the rules are same. Minor difference here and there maybe, but basically rules are same so far as this CC, the procedures and the provisions relating to disciplinary proceedings are almost same in all the relevant rules, either in CC rule or state rules or rules of the relevant concerned PSUs. Now, first of all, how the disciplinary proceeding is started. Disciplinary proceeding is a very important factor for an employee's concerned because it affects his career, his promotion, his service, everything. And so far as management is concerned, if the management is convinced that this employee is not conducting properly, or its continuance is not in accordance with the organization's rules and procedures, then it can initiate disciplinary proceeding, and disciplinary proceeding can be conducted, and after disciplinary proceeding, punishment can be imposed or can be also exonerated from the charges. So there are two types of punishments. First, we'll start over to punishment: major punishment and minor punishment, because procedures are different for minor punishment and procedures are different for major punishment. So for major punishment is concerned, the procedures are the charges have to be specifically framed with specific charges, that is, you have committed this time, this act and this act and this, with detailed particulars. Thereafter, it can be, it will be followed by the supply of documents. The documents relying on which the management wants to, management of the government wants to initiate disciplinary proceeding or wants to proceed against the concerned employee. But before that, I'll just go a little bit. Before disciplinary initiation of disciplinary proceeding also, a person can be placed under suspension also. Suspension always either even before contemplation of disciplinary proceeding or even during continuance of the disciplinary proceeding, an employee can be placed on suspension. Suspension is always held by the different courts, including Supreme Court, that suspension is not a punishment during pendency of the proceeding or before punishment of the pendency of the proceeding. But the suspension can be a punishment also. It is treated as a major punishment. In case of other major punishment, suspension can also be a punishment. If ultimately the concerned employee, sometimes they call delinquent, sometimes they called they are called the charge sheeted employee, whatever the nomenclature relevant rules may follow. But the thing is that ultimately in the disciplinary proceeding one is found guilty, then management can say that suspension period is treated as a punishment, it will be treated as such. If ultimately it is exonerated from the charges, then suspension period will be treated as a duty. Suspension there will be no punishment and suspension will automatically. And during suspension before proceeding or during proceeding, suspension, one has to get suspension allowance. That should be at least minimum 50%. There are also rules where if the disciplinary proceeding is continuing after a particular beyond particular time, then it can be enhanced to 70%, sometimes up to 100%. If the proceeding it has been delayed not on account of the employee but on account of the management, then only enhanced suspension can be. And there are also judgments. There are also the law is very clear. If the substance allowance is not paid, then that will amount to violation of principal natural justice. If that is so, then how it will be if substance allowance is not paid, then an employee cannot defend himself. The both sides, more like how all the rules, constitution, everything will guide the procedures for disciplinary proceeding. And the natural justice is the most important factor to follow, to be followed in the disciplinary proceeding. So, what is natural? When I am speaking of the suspension, if the suspension allowance is not paid, then it is held by different courts that are including the High Court that if they not done, then the concerned employee, the delinquent, is deprived of defending himself properly. That amounts to violation of natural justice, and sometimes proceedings are also passed on that ground. Now the question is that how the disciplinary proceeding is started. Disciplinary proceeding is started basing on this. Now, as I said earlier, specific charges have to be framed. So cause has to be asked for. So cause notice has to be given along with the specific charges. And the delinquent employee is given a chance to give a reply. Sometimes it is called written statement of defense. Sometimes 2 is granted, or 3 is granted, or 4 is granted. So it all depends on the management, or depend on the employee. Employee may ask for some more time, and it is up to the management to grant some more time or not. That is a different issue. But that is also a question of principal justice is there. Let us suppose the management wants to supply within to give the written defense within 7 days. Then the employee says that no, it is not possible. I will not be able to give my written defense within 7 days. Then it has to be please grant me 2 weeks more time. And management refuses. That can be also ground for violation of national justice. Then after framing of charges, question of supply of document. Supply of document is a very important aspect of the violation of principle of natural justice or principle of natural justice. The supply of documents, the delinquent employee has every right to get copies of the documents, basing on which the proceedings are initiated and the charges are framed. Now, sometimes documents are voluminous, so management asks the employee to inspect the documents and take notes. So that is also compliance of natural justice. Merely because copies have not been given, that doesn't mean that natural justice is violated. No, When if copies are not given, but it is voluminous in nature, or it is some not accessible, not possible to give copies to different to the concerned employee within a short time, then employee can be permitted to inspect. If the permit is not permitted to inspect or not even copies, then employee can take it ground before the when ultimately it will challenge the proceeding that yes, personal justice has been seriously violated, and that is also substantial ground available for him. Then comes the appointment of inquiry officer. But when the inquiry officer, now sometimes disciplinary of the rule, different rules say differently. But in case of the government rules, the disciplinary authority can inquire into himself or can appoint another person as the inquiring officer. If the disciplinary authority decides to inquire himself, then it will be he will be treated as the inquiring officer. If he appoints somebody else, then it will be appointed as the inquiry. And another important aspect here in this that inquiring officer has to be, let us suppose the government, let us I'm a manager. Proceeding is initiated against me. So any officer superior to me, deputy general manager, or chief general manager has to be inquiring officer, not of the same rank, or not even my junior. My junior or not of the same rank cannot be. That is the law is very clear in that respect that person has to be superior to the delinquent or the concerned employee who is facing the different proceeding. So what inquiry officer will do? Inquiry officer, now the management will also appoint a presenting officer to present the case on behalf of the management before the inquiring officer. So far as in delinquent is concerned, he has got a right to be represented by himself, or even he can take assistance of another co-employee or any person who is acquainted with the person. At this stage, in some cases, employee can seek a representation by lawyers, but that is not a matter of right. Why? Where the even different Supreme Court judgments and different high courts have categorically laid down that you will let a Supreme Court judgment 2012 volume 2 CC that is in Chairman State Bank of India versus versus M.J. James, that is 2022 volume 2 SEC 301. That the question came regarding the right of representation through lawyer, and their honorable Supreme Court said that no, it is not a fundamental right, or it is not even a substantial right. But if it is the disciplinary, the disciplinary authority, the presenting officer or the inquiring officer, they are lawyers or lawyers thoroughly acquainted with law, and the persons thoroughly acquainted with law, and the charges are based on some laws and some complicated aspects, then the representation through lawyer is permissible. But for that reason, the delinquent has to apply to the inquiring officer to permit him to be represented by the disciplinary authority. Nothing to do with the inquiry officer. He has to apply for the inquiring officer to be represented through a lawyer. If rejected, if we can justify or can convince the inquiry officer that in this case the representation through a lawyer or the absolutely necessary because of these things, the grounds are specific. If they remember, then you can allow him, you can reject him also. If the EO rejects him, that is a ground also in his favor, in favor of the delinquent, so far as natural justice violation is concerned. But why I am saying natural justice, I am giving importance to natural justice because that is the most important part, basing on which ultimately a delinquent can get clear order from the court that if natural justice is violated, so I am prejudiced, so proceeding has to be passed. Management can also say that no natural justice have been followed, no prejudice is caused to the employee, so proceeding cannot be passed, or even the punishment cannot be passed. So that is the reason I am giving natural justice have many facets. Now, after this, now the question comes opportunity of hearing. Opportunity of hearing, what it means? The management can examine its witnesses, based on which it is trying to prove its charges. The employee, delinquent employee, has right to cross-examine those witnesses, and if the cross-examination is not allowed, then also there is violation of natural justice. The consequence allowed, then there will be no violation of natural justice. And here, very important aspect is sometimes the claimant, basically, let us suppose I claim before the management, this person is claiming is demanding bribe from me or harassing me, is not doing the work. So, basing on my complaint, proceeding is initiated. Ultimately, if I do not come forward to depose, then certainly the proceeding cannot be initiated. The proceeding is the decision proceeding initiated. In absence of my statement, that is also illegal. That is also Honorable Supreme Court has categorically. I will give the citation. Citation that no, it is not permissible. And also, even if let us suppose I am examined. I examined myself, I offer as a witness and I am examined. I may be part of the organization, or may not be part of the organization also. I may be some outside person also. So I'm examined, but I'm not coming for cross-examination. Then also, if the cross-examination is not done, on that basis itself, proceeding can be passed. And this is at this stage, I'll just give a reference of. I will speak about because different high courts have got judgments in this respect because it's now at the lecture on national level. So I'll give the citation only Supreme Court. There is Hardwari Lal versus State of Which and DP and others, 99 volume 8 SEC 582. And it's a clear that inquiry is vitiated. It is honorable. It is categorically said inquiry is vitiated in violation of natural justice and concerned employees entitled to be exonerate of the charges and deemed to be in service or whatever the finding the court may give. That's it. Then the question will come. Exemption on witnesses and inspection of documents. Then inquiry report. Inquiry report is a very inquiry report. The inquiry officer has the responsibility to give finding on each and every charge. He has to find him guilty or not guilty. He has to give specific reasons basing on which he gives this finding, either finding concerned employee guilty or not guilty. I'm telling about in general, all the government organizations from PSUs as well as the state government to central government, the procedure is almost same or similar. There may be little bit difference of procedure in different rules, but I cannot say about the difference about here because I have been conducting cases on behalf of the petitioners, the delinquent employees, so also for the management. So I'm acquainted with both sides, but it's not possible to say here in this case because it is a national, national level lecture. So now what has happened? The inquiry officer has to give reasons, either finding him guilty or not guilty. Let us suppose there are 5 charges. Inquiry officer says that 3 charges I found him guilty, 2 charges I find him not guilty. Sorry, I find him not guilty. Now what will happen? This report will be submitted before the inquiring officer, disciplinary authority. Disciplinary authority will then examine it. Disciplinary authority, if let us suppose the inquiry officer says that no, I am not, I do not find guilty instead of all the charges. Disciplinary authority has every right. Sorry, every right to say that to say that no, inquiry officer has not conducted properly, or if inquiry officer's findings are not clear, that is contrary to records, and so it has to give specific reasons for differing from the inquiry officer's finding. And with that reasonings, it has to send notice to the concerned delinquent employee that this is the report and these are my findings, that on this ground disciplinary authority doesn't agree with the findings of the inquiry officer, and what have we got to say? The concerned employee, delinquent employee, has to give a reply, or may choose to give reply, may not choose to give reply. That is a different issue, but can give reply saying that no, the inquiry officer's report is this, and but your findings are not contrary, not in accordance with law, or in accordance with the facts and or the documents on record. So it can, in that case, disciplinary authority can take a decision on the punishment or exoneration. If the disciplinary authority is convinced that yes, the inquiry. 1 minute. Sorry, for a minute. If the disciplinary authority finds that no, the findings of the inquiry officer is not correct, and the explanation given by the concerned employee is also not acceptable, then it can go ahead with the punishment or exoneration. It can punish the concerned employee, and it can also exonerate the concerned employee. I'm speaking all this about major punishment. Later on, I'll speak about the minor punishment. The procedures are as I have said earlier, the procedures are totally different. Minor punishment procedures are different, and major punishment procedures are different. So then, after the punishment is imposed, if exonerated is well and good. If the punishment is imposed, 1 minute. If the punishment is imposed, then the concerned employee has to the right of appeal everywhere in all the rules. Right of appeal is there almost. Only difference is that if the right of appeal is not there, in case of, let us suppose the topmost, let us suppose chief secretary or the principal secretary of a state or the, he is punished. Then what will happen? He has no right of appeal because ultimately it is given by the President of India. Punishment is given by the President of India is the disciplinary authority. So there is no right of appeal. We cannot prefer an appeal to whom it will, because the highest body has given the punishment. So his next course will be to approach the court, either tribunal, state administrative tribunal, or central administrative tribunal, or high court, wherever it is possible, whichever authority has got jurisdiction. Now, the thing is that the disciplinary, after the imposition of punishment, the concerned employee, concerned employee will think that, oh, punishment is not that much. I am not going to be affected by that, or I'm not going to proceed further. It may choose not to be for appeal also. Then he has to accept the punishment. Now the question is that the appeal, what grounds he has to take in the grounds in the appeal are very important aspects, because he has to specifically say in the grounds how he has been prejudiced by non-performance of the, or the violation of the rules, misconduct of the management or the presenting officer, or also of the inquiring officer also. Because if the inquiry officer has not conducted properly, that can also ground for, and he has to say that he has been prejudiced. Again, I'll say that prejudice is a very important aspect in courts of national justice. He has to convince the court always that the concerned employee is prejudiced. Prejudice in the sense that he has suffered. Because of these things, he has suffered. Merely because, let us suppose, he has asked for 10 documents. 5 documents are given, 5 documents are not given. And that is violated. No, that he has to explain to the court or the concerned authority that yes, these 5 documents are relevant, and based on the 5 documents, I can build up my defense. Based on the 5 documents, if the 5 documents are not supplied to me, then I'll suffer. I'll suffer and I'll be highly prejudiced. Merely saying that I'll be highly prejudiced will not make him prejudiced. He has to convince the court. Prejudice, but there are many judgments on the question of prejudice, because every violation of national justice cannot be ground to set aside one punishment. Court have very normally. Later on I'll come to the on which grounds the court will interfere with the disciplinary proceedings or the punishments. So what happens is any kind of violation of natural justice will not be a ground for it. He has to convince the authority or the court concerned that because of this particular violation, I'm prejudiced. I'll suffer because of that. Let us suppose an important document. That document itself shows that he's innocent. He has done his duty. The document is there. Management has not produced the document, or management has not given a copy of the document even he asked for. Then he can say that this document I have brought to the notice of the management that yes, this has been it is not my fault. It is the fault of such and such. and I should not be punished for the fault or for the mistake committed by somebody else. If I am able to convince that, then certainly court, the authority can consider it and say that no, non-supply of this particular document amounts to violation of natural justice. Similarly, witness. If important witness, as a defense also, as a delinquent also, I have got right to examine the witness. I can also examine, I can also ask for any government, any employee of the organization that yes, such and such employee is to be examined on my behalf, though I want to examine him or I want to cross-examine him, though he has not been cited as a witness by the management. That also, he has to convince the inquiry officer or the authority or the court that yes, that witness is very important, because that witness, based on his testimony of that particular witness, my case will depend. My defense will depend. I'll be able to build up defense. Or if that witness has not been examined, is not being examined, then I'll be prejudiced. So this is how prejudice has got an important role to play. That I have stated. Now, what happened? So far the ground of appeal is concerned. If the ground will have to state before the read, I have not taken the grounds before the appellate authority. Sometimes courts have said that you have not taken it a ground in the appeal, because appellate authority is not an ordinary appellate authority. Appellate authority has to consider all aspects, factual aspect as well legal aspect, and the every rules, whether the rules have been followed or not. Rules have been followed or not. If the rules have not been followed, then the appellate authority can also set aside the findings of the disciplinary authority, set aside the punishment also, and also has to give specific reasons. Sometimes what happens, appellate authority simply says, oh, I agree with the findings of the inquiry officer without giving reasons. Concerned employee challenges in court. And court says that no, appellate authority has not given the reasons. Stop. They sometimes set aside the appellate authority judgment and decision and remit back to this appellate authority also. On many occasions, they have also remitted. Appellate authority, depending on the rules, appellate authority has also right to reduce the punishment, not enhance. Enhance means that the rules have to, if they want to enhance the punishment, then separate procedure has to be followed, separate thing has to be done. We cannot enhance easily, but he can, appellate authority can reduce the punishment. And very important is that you have to say that he has to apply mind, and it's not a mere post office that appellate authority simply confirms with the disciplinary authority finding and all that. No, he has to apply him. He has to, the appellate authority has to apply his mind. Apply his mind means judicial mind, a logical mind. Appellate authority will not certainly a low court or something like that. So it has to apply logical mind. Logical mind. What is logical mind? They have to say that yes, the concerned employee has taken this ground and violation of justice. Actually, he has not followed the this particular, we have violated the particular rules or the procedures provided in the rules, or has not followed the natural justice. That is it. Or on the other hand, it says that yes, the delinquent employee or the appellant has taken this ground, but I find on assessment of the evidence, or assessment of the rules, that the ground is not sustainable, so ground is rejected. The ground is rejected, appeal is dismissed. Thereafter, man comes to the court. Now, at this stage, on what ground the court can interfere? There are up to number of decisions on this year, but the basic decision I would say it is BC Chaturvedi versus BC Chaturvedi will come later. Now the court's interference of the year will be. Now, before coming to this, I will mention the question of if a concerned employee proceeding is initiated while he was in service, in course of pendency of disciplinary proceeding, he has retired. There are rules governing the field. Some organizations earlier, and even from banks, some even I had argued, now I am the senior advocate for NALCO, but when I was not the senior advocate for NALCO, a director was punished after retirement. So I challenged that ground, I have challenged that case, challenged the punishment in the High Court. High Court said, after retirement, master servant relation switches. You cannot initiated proceeding, or if proceeding was initiated before his retirement, but after retirement you cannot punish him because master and servant relationship ceases. Because the most important factor, the existence of master and servant relationship. The master and servant relationship is there, then only proceeding can be used. So I'll take the particular Niladri Mahanti versus Nalco, that the case was that. So what happened after the retirement? He was punished. I challenge the court, said that yes, after retirement, when there is no rule governing the field, that there will be continuance of the proceeding after retirement. Master and servant relationship ceases, so cannot be punished, and he was exonerated. With that proceeding was passed, and he was treated to be not to have been punished. But subsequently, after that judgment, NALCO changed the law. NALCO incorporated the provision that after if the proceeding is initiated before the concerned employee has retired or he was in service, and after retirement, if it continues, then proceeding can be continued. Similar provision is there in every state or central rules also. There, the rules for concerned pension rule, even the service was pensionable previously before 2005. State government and central government employees were pensionable establishments. So concerned pension rules are there. Concerned pension rules will be continued, and what kind of punishment can be given, that is also provided in the concerned pension rules. But now the question is that after punishment, after retirement, can the concerned can be imposed major penalty, including dismissal of service and the major penalty, or gratuity can be paid or not. That case, there are divergent opinion of the Supreme Court. There are different judgments of the Supreme Court which were that way, but ultimately it came to be settled in BC Chaturvedi, chairman chairman का mandated Mahanadi Coalfield versus Raminath Chobe. That is reported in 2020. SEC online 470. That SEC online it can be found. It's a very important decision. In that decision, it is held that no, it can be imposed. Major punishment can be imposed. Major punishment can be imposed, and it can include dismissal. What it means? While he was in service, he could have been treated as if he has not retired, as if he has, while in service, he has been dismissed from service or removed from service. Removal from service. It will all depend on the relevant rule. If the relevant rule provides, then if the relevant rule doesn't provide, that also. Every proceeding, every punishment, every finding of the disciplinary authority or the authority, all depend on the relevant rules. Rules are very, very important. Rules are almost similar, but there are some different rules also by different organizations. Because some banks, they follow a different rule. Sometimes they follow a different rule. They say that for the purpose of disciplinary proceeding, the man, the concerned employee, has been facing the disciplinary proceeding and retires during pendency of disciplinary proceeding, they will be deemed to be continuing in service for the purpose of disciplinary proceeding, not for the purpose of working in the bank. For the purpose of disciplinary proceeding only, he will be deemed to be continuing. It means he is an employee till disciplinary proceeding has its logical end. If disciplinary proceeding has its, it doesn't have the logical end, then also it cannot be. Then the concerned employee has to be exonerated. That has to be. Now the question is that after retirement. Now this is the question that the employee is continuing before retirement and the employee is continuing the disciplinary proceeding after retirement, beyond retirement. Now the question is that the disciplinary proceeding has not been initiated before retirement, but the disciplinary proceeding is initiated after retirement. What is it? There also the concern, the relevant rules are there. Central government and state government rules are there. That I was referring to the pension rules that you provided in the pension rules, not under the concerned CCA rules under that. Pension rules procedures may be same, but the concerned pension rules, that within normally it happens within 4 years after retirement, the proceeding can be initiated. The action has been done within before the 4 years. then only proceeding. If beyond the 4 years, automatically it becomes time barred. Let us suppose I retired in 2014, but 2018 they come up with a disciplinary proceeding. So that while you were working as a manager or some concerned as a particular capacity, you committed such type of mistake, misconduct and all that, you misappointed or conducted misrepresentation. That is not permissible. For that reason, has to say that no. You'll have to show that within management has to be very careful to initiate the proceeding within 4 years after retirement. And that will also depend on the relevant rules. But normally government rules are there for your central CC rule provision is also almost same. Central state CC rules are the central CC rule also same. Because central, that is called central civil classification or appeal rules. As relevant state civil classification appeal rules. Let us say in Odisha, Odisha civil classification or Punjab civil service classification rules like this. So, like this, the proceeding, initiation of the proceeding before retirement, initiation proceeding after retirement, are very important. So, an employee cannot be very happy that I have committed so lot many blunders, lot many. I have misconducted myself so many times, but I have after retirement I am scot free. No, he cannot be treated as scot free. Banks have got different banks, different PSUs. There are state PSUs as well as central PSUs. They have got different rules. Now they are very careful in providing these provisions in accordance with the CCA rules and in line with CCA rules, either central or the relevant state. Then the question is that the effect on promotion. Now disciplinary proceeding is pending, and question of promotion arises. In that case, normally rules are almost similar, but sometimes rules are also different. But sometimes rules are there that if disciplinary proceeding is pending, then one has to his case should be considered or kept in sealed cover. After it is disciplinary proceeding disposed of, if it is a minor punishment, he may be given promotion. That will depend on the rules. If they given major punishment, he may not be given promotion. And also some rules are there in case of, let us suppose 5 minor punishments are there. Then also it will be treated as major punishment. Let us on 5 times he has been punished. It all depends on the circulars, guidelines of different organizations, different state government, central government like this. The circulars guidelines are there. Circulars guidelines act in aid of the rules, not in violation of the rules. Any circular or guideline cannot be in violation of the rules, in aid of the rules. If it is in violation of the rules, certainly that circular has no legal existence or legal cannot be accepted as a law. Accepted as law, it can be easily passed. But if it is in detailed procedures are provided in accordance, in line with the procedures laid down in different rules, then circulars can be followed, and violation of circular cannot be ground. Now, question is that the circulars sometimes in some cases 5 minor punishment, 4 minor punishments are also treated as one major punishment, and one can be deprived of promotion also. Major punishment also, it all depends on the management what kind of major punishment is there and whether it will be given promotion or not. But basically, major punishment is improved. Major punishment can be major punishment can be removal from service. Major punishment can be reduction of rank. Major punishment can be stoppage of 2 increments with cumulative effect. So that way it can be done. Now the question is that another important before going to the next question, I will come to the minor punishment. Minor punishment, whatever. Let us suppose the misconduct is not that serious. Management says that no, misconduct is not that serious, so it can be treat initiate a minor proceeding for minor proceeding for minor punishment. In that case, what normally procedures are very simple. In that case, normally what it can be seen that penalties are ensured, withholding of promotion, recovery of pay from the whole part of the pecuniary loss, that is also treated as minor punishment by the central rules, and also reduction to a lower stage and withholding of increment of pay, that is treated. But so far as minor penalty is concerned, I'm speaking out the minor penalty, but so the minor penalty is concerned, the procedure, the procedure is that give some disciplinary proceeding. They just to show cause notice will be issued against him. After the reply to the show cause notice, they may straight away conduct inquiry or without going for this detailed procedures as I stated earlier. They may go to that is called they call it inquiry. What they call it? Preliminary, not preliminary inquiry. They call it summary inquiry. Summary proceeding. In a summary proceeding, they can dispose of the proceeding and say that he is found guilty or not guilty. Accordingly, punishment is there. Normally, manner punishment, courts are very to interfere in manner punishment. Court normally do not interfere in manner punishment unless there is a blatant violation of the rules or blatant violation of natural justice also. It's also playing an important role in this case. And so far as major penalty is concerned, that I have already stated. What is the major punishment? Different. I am just in detail. It is that the reduction to road scam, removal from service, compulsory retirement, dismissal from service, and also can be said that suspension and other parts will also there. Pecuniary loss and all that, it can be recovered from its entitlements and all that. So now what has happened? After this, there is another round of litigation comes or another problem comes. Let us suppose criminal proceeding. Let us say I have not misconducted myself as an employee, but I have committed some criminal offense. Based on that, also disciplinary proceeding can be initiated. Both the law is very clear that both disciplinary proceeding and criminal proceeding can now simultaneously. I cannot say that it cannot be that because I am facing criminal proceeding, not face disciplinary proceeding. And the law is also there that if I'll have to show my prejudice, if I show my disclose my defense with the disciplinary authority, then highly prejudice in criminal proceeding. Let us suppose serious offense, not a serious offense of murder or rape or some other serious offense is there, or dactyl or some other serious offense is there. Then also I can seek, I can pray for pending, keep the disciplinary proceeding pending till dismissal of the criminal proceeding. After dismissal of the criminal proceeding, disciplinary proceeding can continue. Even if I am convicted, disciplinary proceeding can become continued. If I am not convicted, even acquitted, also disciplinary authority can proceed and also find him guilty. That is also that disciplinary authority remedy lies with the disciplinary authority to even proceed in accordance with the as per the disciplinary proceeding rules, even if after he is acquitted. There are different kinds of acquittal: honorable acquittal, benefit of doubt acquittal. Honorable acquittal also the law is different. Doubtful and the basically benefit of acquittal, benefit of doubt also. It cannot, disciplinary authority cannot treat the acquittal as a full acquittal, and also can proceed with disciplinary proceeding and also can punish the concerned employee basically self-claim charges. But now the question is that is another way, the preponderance of probability. That is most important. Preponderance of probability. Now Supreme Court has come to a different year. Sorry, time is over, I think.
It is so interesting.
Time is over, I think. Time is over, I think. I will take only 2 minutes. Can it be permitted?
Most definitely, sir. Most definitely.
Only 2 minutes. If the discipline, because it helps both the management and the employee. If the charges or the allegations basing on this particular disciplinary basing on which disciplinary proceeding initiated, so also the criminal proceeding, the allegations are exactly the same and the same. Then the Supreme Court has said that no, continuance of this after the person is acquitted in a criminal proceeding, is honorable acquitted in a criminal proceeding, then continuance of the disciplinary proceeding within the same charge is not proper. And they have also gone to it. That Supreme Court judgment reference I can give it. GB tank case. Sorry, GM tank case. GM tank case is just 1 minute because it will be reference will be easier for the lawyers. GM tank case, that is 2006 volume 5 SEC 446. 446. Because in this lot many litigations come in this aspect. So this is all in, though lot many things are there, but time is short. But this is the overall, this is related to disciplinary proceedings, both of in respect of government employees as well as the PSUs. And now only last answer, the court's interference. On what ground court can interfere? None. Court have got very, court can interfere. Court cannot interfere in normal course. That should be my last year. Then that is in the proceedings, the I just permitted that may interfere when the authorities held the rules of natural justice or violation of statutory rules prescribing the mode of inquiry or the conclusion finding this by the disciplinary authority is based on no evidence. In the conclusion of the finding be of such be such as no reasonable person would have ever reached. The court or tribunal may interfere with the conclusion of the finding and could also mold the relief. Court has also some power to, in this one aspect, the court has also to either set aside the punishment or may direct the authority to reconsider to start the proceeding afresh, based on the concerned following the rules. And if the court finds that the punishment is shockingly disproportionate to the allegations, then previously some decisions was used to say that the court can modify the punishment, but subsequently Supreme Court has categorically said that no, it cannot be. Court cannot mold the punishment. Court will direct the disciplinary authority to mold the punishment, saying that it is shockingly disproportionate. For natural minor offence, one is removed from service. Court says that no, though he is found guilty, but it is shockingly disproportionate to the allegations made or the charges framed. Then court can say that no, this discipline proceeding, this removal from service is shockingly disproportionate. So giving some other minor punishment or some lesser punishment, like this way, and that this is all so far as discipline proceeding is concerned in nutshell. Okay, Mr. Sarna.
Yes, sir. Sir, I will be honest with you, sir. It has been actually, there was just no scope of asking you to even stop because it was to the point and you have practically covered all the aspects with respect to the procedures and the rules governing disciplinary proceedings. And it was truly a privilege listening to it because I know that I'll go through it once again. I've taken my notes, but I'll go through it once again. I know that for sure. So, again, sir, we have crossed the time, and
I convey my thanks to you, so also to the listeners. I hope it will be of some help to them, and it will.
I'm sure, but right now also there are certain few questions which have come up.
Yes, no, I am prepared to answer it.
So, sir, Mr. Yagna Dutt has a question. Yagna, sir, would you want to ask the question yourself? He has two questions actually. So, would you want to ask the question yourself?
You please continue, Keshav sir.
So, please, you may ask.
You can ask.
Okay. So, sir, his first question is, he says, sir, good morning. Can you please differentiate between corruption charge proceedings and disciplinary proceedings?
Corruption charge disciplinary proceeding, corruption can be a charge also. Corruption charge, the dependent proceeding can be initiated criminal proceeding as well as the disciplinary proceeding also. What happens sometimes, vigilance or CBI, as the case may be, they initiate this criminal proceeding for the corruption cases like the disproportionate asset cases, or one is trapped while taking bribe. The criminal offense is at that simultaneously, as I said earlier, simultaneously disciplinary proceeding can also be initiated. Let us suppose the concerned management doesn't intend to initiate criminal proceeding. It can, in a disciplinary proceeding also, it can come out with the charges that you are indulged in corruption in the, involving such and such amount, and giving the specific instances and citations and specific. But management has to be very specific in that allegation. General allegation that yes, you are found to be corrupt, your activities are not beyond doubt, or you are indulging in corruption activities, that will not be sufficient. Management has to, as I have also stated, management has to give specific reasons on such and such date or such and such occasion, you have your action is such that you have indulged in corruption and all of that. I hope Mr. Dutt will get the answer.
So he has another question with respect to this, which is violation of standing orders of employees.
Yes.
Is it a minor offense or a major offense?
What violation of standing orders?
Standing orders. Yes.
Standing orders. There is a standing order act in respect of the persons who are not the workmen. They are not governed under these rules, concerned rules. They are governed under the employment standing order. There is just an act for that purpose. So it will all depend. The violation of the standing order means standing order. The relevant procedures are provided in the misconducts are also provided in the standing orders, like the CC rules and other relevant provisions of different PSUs. So if there are also standing orders also, the provisions are there, what will be minor offense and only major offense. That is also there in the standing order. It all there is a model standing order and there are different standing orders of different organizations also. There is a model standing order of the that is a statutory standing order. And so it all depends on the nature of the violation.
So again, very briefly, I want to ask everyone if there is any question which anyone else wants to ask, then right now is a very good time. Please raise your hand or share your question in the chat box. Otherwise, I will continue with my questions. So one very small question that I have, which I've faced with respect to whatever PSUs I've had any kind of exposure with. So what exactly are the considerations that the disciplinary committee, considering that it is generally comprised of the people who are within the organization? So in brief, if you can just share that what should be there in their mind while they are trying to adjudicate or any matter or met out any sort of a punishment.
Please repeat your question again.
So say there is a disciplinary committee for any organization.
Yes.
Now, if when they are adjudicating a case, when some case comes to them, that some case file they have to see with respect to any allegations which have been leveled upon any other employee.
Yes.
So, sir, what should they be thinking? How should they think when they are going through the case, and with respect to giving the punishment, that which punishment is enough, which is not?
Yes. Disciplinary committee, either disciplinary, maybe disciplinary, there may be one or more inquiring officer. Even there can be disciplinary authority can be can consist of more than one employee or two more employees or three employees. But what I think that they always think about, they should think independently. First of all, unbiasedly. Because the role is that they are unbiased. Maybe they are employees of the organization, but they're unbiased. They has to be like arbitrators. They're unbiased. What happened? They should not think about the management as well as the workman. They'll have to think independently whether this employee has really misconducted. If they're convinced that this employee is misconducted himself or has committed such type of irregularities which are very serious in nature, then they can think of. Then they will think about the management. That if such an employee is not continued in the employment, then what will happen to the management? Management will have to bear with such type of indisciplined employee or the corrupt employee or any kind of person who is not doing any work. Sometimes indisciplined misconduct also sometimes goes to office and doesn't do any work. That is also kind of misconduct. That doesn't do any work. So that way, whether this will be so accordingly they can think of but disciplinary authority, inquiry authority are not authorized to propose the punishment. Their duty is to simply find that whether the concerned employee is found guilty or not guilty. Sometimes I find that disciplinary authority they recommend that he should be punished from service, he should not be removed from service, it should be given. So that is not coming within purview of their nowhere. Law doesn't permit, no rules also do ever permit. Even the rule permits also, that will be illegal. Even if any rule permits that disciplinary authority is inquiring of authority can suggest punishment, that is also not. If it was punishment or no punishment, it is the sole prerogative of the management. Only management can decide whether this man should be given if the punished or if punishment is to be given, whether this punishment or that punishment. that is to depend, that has to be within. The management also cannot go beyond the rules. If the rule provides the specific punishment, then he has to choose, or he has, let us say 4 punishments are provided in the rules. He has to choose 1 or 2 out of them. Not we cannot punish beyond these 4 punishments provided in the statute. So basically, the disciplinary inquiry, disciplinary committee has to act independently, unbiasedly.
So that's again, that's really a great insight.
Keshav,
Yes, sir.
Keshav, I want to ask one question.
Yes, sir. Please ask.
Yes. Sir, can you just put a light on exoneration of the person in the disciplinary or a departmental inquiry or the disciplinary proceeding, and then what is the effect of that exoneration on the criminal case which is pending on the same cause of action?
Exoneration, disciplinary authority, inquiring officer, on finding on the relying on the evidence on record, either oral and documentary, he can exonerate the concerned employee. Can say that the concerned employee is not found guilty and he can exonerate. And that exoneration is also subject to acceptance with the disciplinary authority, as I have said earlier. If the disciplinary authority doesn't accept this exoneration, then here disciplinary authority can give specific reasons of for not agreeing with the exoneration and say that no, I do not agree. That is a different issue. Now your next question is that what is the effect on the criminal proceeding? This exoneration has nothing, cannot have any effect on the criminal proceeding, because criminal proceeding evidence is totally different. Totally different. Let us suppose it is a case of corruption. Corruption, let us suppose one comes with the allegation that such being the position, in a position he demanded 30,000 rupees from me as a bribe, and basing on this I had to pay him bribe, or I did not, because I did not pay him bribe, he did not do my work, all these things. So, and so far as criminal case is concerned, criminal court also very same allegation, management also can file a lodge FIR that this person demanded bribe of 30,000 rupees. So in that case, little bit different. In that case, the same complainant who comes before the disciplinary authority first says that yes, I have not lost such type of complaint, or I have not this claim of demand of bribe is not law, is not a fact. It's contradicts himself. Whatever he has stated or stated in the complaint, contradicts himself, basing on which he can be exonerated. But before the criminal court, he says that no, he has demanded the bribe and he has taken the hit. There, it is up to the criminal court to consider how this evidence is trustworthy. Criminal court can find that this person is not trustworthy, because before the inquiring officer, he says that there is no demand of dowry, but here before the court, he comes that there is a demand of dowry. So it has got some link, but the criminal proceeding, criminal court is not bound by the finding of the disciplinary authority or the inquiry officer. Okay.
Because many of times I have seen and I have experienced on the basis of the exoneration order given in the disciplinary or a departmental inquiry committee or a board, they pay for discharge before the criminal courts.
But that I said that I said one cannot be discharge is not normally permissible basing on this. As I said, the witness, very same witness, comes before the disciplinary authority, said that no, there is no demand of dowry. He had not demanded dowry. I'm sorry, demand of bribe. He has not demanded bribe from me. And basing on this, the concerned employee is exonerated. But very same person comes before the court, said that no, I have, and when framing of charge, before framing, at the time of framing of charge, his exemption for the court doesn't arise. He has not been examined by the, he has not come to the court as a witness. So when he comes to the court as a witness, only his statement whether there is a demand of bribe or not, that is to be seen. That demand of bribe or not, it is to be seen. That only his credibility is to be judged by the court. So basically, the one cannot be discharged on that basis. And criminal court is not bound by the finding of the inquiry officer or the disciplinary authority.
Correct, sir. Thank you, sir.
Thank you. Most welcome.
So still lots of questions, but we've just reached beyond the time, and so I think maybe just 1 or 2 small questions probably.
No question. No. No question. Even.
So thank you so much, sir. So, sir, before I take my question, sir, there is this question from Advocate Rashma Behra ji, and sir, Reshma Behra ji, she has asked, sir, any specific rule book available for NALCO, NALCO, and where is it available?
Sorry.
And where is it available? NALCO, so specific rule book for NALCO, she wants to inquire.
NALCO has got separate rules for disciplinary proceedings. NALCO has got separate rules that is available on website. Website it can be made available. NALCO website it is available. It can be available in it is available under the website. NALCO website will be available. NALCO has got separate rules of disciplinary proceeding. Of course, in accordance with, in line with central CC rules, but it has got its own separate rules. Some rules are also a little bit different from the central CC rules, but they are governed by their own CC.
So I think that answers her question. And so before I take my final question, is there any other question which anyone has? Okay, so sir, I'll come to just this one final piece of advice only, sir. And sir, this is for any person against whom any proceeding has been initiated. When that person receives notice that such and such proceeding has been initiated against them, what should be their contemplation, or what would be your advice be to any such person who receives such a notice, so that he may
First advice is normally people what they say. I have also got different. So let us suppose the man is a poor man, or it's not basically illiterate man or poor man, or sometimes even if he's not poor, but sometimes management people say that you just simply agree to the so we'll see that nothing will happen to you. We agree to the allegations, and sometimes they are carried away, they are biased. Management people, the management with some higher rank, higher officer in the concerned management, say that, oh, we agree with it, nothing will happen. We'll see that nothing will happen to you, and you will continue in service, and you will get your regular promotion and all that. Nothing will happen, just agree with it. There, the concerned employee, even if educated or non-educated, having a small rank or higher rank, if he agrees to that suggestion of that higher officer or any other friend, then he commits a blatant mistake. He committed blatant mistake. Whatever, once you admit means, it is not like criminal case. Criminal case, based on admission, one can be convicted, one cannot be convicted, because if there are no other materials on record, no other corroborating evidence on record, then based on admission also, one cannot be convicted. But one can be convicted. Let us suppose they admit that yes, I have committed murder of this person, or I have committed dacoity. But if there are corresponding evidence, then only this will be ground for conviction. But if I admit and there is no other prosecution has not able to any evidence or cite an evidence that yes, this man has really committed the offense, then based on my admission, I cannot be convicted. Even if I admit that I have committed murder, I have committed dacoity, or I have committed rape, or whatever serious offense or minor offense I have committed, that will not be. So similarly, here what will happen? Now we are coming about. In dependent proceeding, if we once he admits means automatically treated to have been proved. No management is not required to adduce any evidence. Based on that, he can be punished. Normally, what employees commit that they come to the law when ultimate punishment is imposed on them. Then they come to the, like we go to a doctor after we cross the first stage of the cancer, when we are in the first step of the death, on the verge of the death. Like this, the doctor cannot do anything. So my advice to all the concerned employees, if they, that you whenever you get a notice from the management, you should approach a lawyer and act in accordance with his advice. Written statement of defense should be drafted by the lawyer. Lawyer having sufficient knowledge on disciplinary proceeding. All the lawyers may not be having sufficient knowledge on disciplinary proceeding. Lawyer having sufficient knowledge on disciplinary proceeding, he has to go to him. He has to find out, like when we are ill, we go to a good doctor having the specific knowledge on this particular subject, particular disease. So like this, you'll have to go to a lawyer. You may not go to a very, very big lawyer, but you may go to a standard lawyer. but take his advice, and on his advice only you act. He will be your background guide for course 7 years. If you do that, then lot of things happen. Sometimes what happens, the clients come and say that, bro, I have been prejudiced, I have not been given documents and all that. So please file a writ application and I want to all my documents, all my these documents, I want this exemption witness to be examined and all that. Lawyer files the case. Let us suppose court allows it. What will happen? Even after everything, management wants to punish a particular person, management can punish. Thereafter, this ground will not be available for him to be challenged in court. Ultimately, that is the reason why normally we advise keep it as a shield, keep it as a weapon. This weapon is open. You can take it as the ground in the appeal, and after ultimately when you come to court, this will be our Brahmastra. Basing on this, within 5 minutes, we will get court can set aside your punishment. Court can pass your punishment. So these are the normal, when we advise the lawyers also, my advice to the lawyers also, when they are advised to the clients are also not immediate relief, but ultimately what relief can the client can get. Most of the cases, sometimes judges, the good judges are also there. Judges also, they say that, I can pass this order rejecting the your request for supply of document or supply of this exemption on this witness. But if I said, will ultimately what will be your ground left to, what is the ground left for challenging the punishment? So keep it ground as a seat. Some judges, good judges also advise that no, it is not in the interest of your client. The other advise your client to keep it pending and if management wants to punish a person, means whether materials are there or not, they will immediately punish. They want that punishment be there, let him go to court of law, let him get it certified, but he wants to punish. So sometimes, in some cases, management, some concerned high management, they also ego is concerned. Sometimes genuine proceeding are also, sometimes ego party is concerned. So far as management is concerned, I am saying management, this is reported employee is concerned. So management is concerned. That is also management. Normally, management has got a legal team, or either they have got officers from law, I mean having experience in law graduate, or some they have got dedicated lawyers are also there. So for management also, for anything, their law department is not competent or is not sufficient, then they have to take the advice from the lawyer concerned. May not be to a senior advocate, but from a normal, their advocate on record, say that yes, sir, we want to punish this man by anyway to guide us. So that lawyer can also guide how to punish that employee, even if even so by complying with the rules and procedures and natural justice, that how the person can be punished. So it is advice to both employees and the management also.
So I only understand one thing, that whosoever has had the opportunity of listening to this session with you today will greatly benefit in terms of not just understanding the rules and procedures, but also in terms of devising strategy with respect to approaching such matters. So
Again, convey my thanks to your listeners and to Mr. Sarma, to you also, for giving me this opportunity to be of some guidance so far as lawyers and the persons and the clients are concerned, or the concerned persons are concerned.
most definitely, sir. Most definitely. So I very humbly thank you on behalf of our family, our Vestralex family, our community class initiative. So it's a very humble initiative, and it's only the likes of such uh, such heavyweights and such learned people such as yourself who make sure that this initiative in whatsoever respect is to whatsoever. So we don't know, sir, how it will benefit people, but I know for sure because I have personally referred to such videos and taken such advice at points of time from online and audio visual material. And it's just the fact that such people as yourselves have taken the time out since time and time again to teach young generation of lawyers such as ourselves the nuances of law and the legal practice. And so I am really grateful, sir, to you and so all that you have done and accomplished to be able to come and help us out and guide us with respect to how exactly to approach not just disciplinary proceedings but entire service matters, sir. Actually, you've covered. So, but sir, I really do hope that someday we'll be able to speak about private organization matters also, sir. That
Yes,
how
yes.
exactly they're
The private organization law is there is very important aspect is that if you speak sometimes there are many things are there in private organization. Many things are there. You
So it
can,
will be our uh, pleasure and privilege to be able to host you to discuss that also in the future, sir.
thank you.
So, sir, with your permission and with your blessing, sir, may I close the class today?
Thank you. Thank you.